Good evening, everyone. All right. So today we're doing remedies. We're now on to injunctive relief as a remedy. And the first case we have today is Almurbati versus Bush, a 2005 case, Bush, the second Bush. You'll understand very quickly what this case is about. The plaintiffs are 6 Bahraini nationals who've been classified as enemy combatants and held at the United States Naval Base at Guantanamo Bay. They filed a petition for habeas corpus seeking their release. Then they filed a motion as a part of the habeas case for a preliminary injunction forbidding the government to transfer any plaintiff out of Guantanamo Bay without 30 days' notice to the court and to their counsels. Walton, the district judge for the Federal Circuit in 2005, writes the opinion. The petitioners allege they, quote, stand to suffer immeasurable and irreparable harm from torture and possible death at the hands of a foreign government like Pakistan, Afghanistan, Saudi Arabia, or Yemen if they are transferred to such a country. They have submitted no evidence in support of their assertions that they will be transferred to such a country. Instead, petitioners rely exclusively on a range of allegedly credible news reports and statements from 2 of the petitioners in this case. For example, the petitioners cite an article in the New York Times. The article alleges that the United States government is, quote, contemplating a plan to cut by more than half the population at its detention facility in Guantanamo Bay, Cuba, in part by transferring hundreds of suspected terrorists to prisons in Saudi Arabia, Afghanistan, and in Yemen, end quote. According to the petitioners, media reports have represented that, quote, the U.S. government has reportedly transferred detainees into custody of foreign governments that employ inhumane interrogation techniques, close quote. Moreover, one petitioner alleges that he was told by an unidentified United States official at Guantanamo Bay that he, quote, would be sent to a prison where he would be raped, end quote. Another petitioner alleges that he was also told by an unidentified U.S. official at Guantanamo Bay that, quote, he would be sent to a prison that would turn him into a woman, close quote. Notably, however, the petitioners do not allege these statements were made by officials who play a role in determining where they will be sent upon their release from Guantanamo Bay. Despite these admittedly disturbing news reports and the allegations of the 2 petitioners, the respondents have submitted declarations refuting the factual scenario that prisoners portray. Specifically, the respondents state that, quote, it is the policy of the United States not to repatriate or transfer individuals to other countries where it believes it is more likely than not that they will be tortured, end quote. To ensure that such repatriations or transfers do not occur, the Department of Defense represents that it consults with other agencies and considers factors such as the particular circumstances of the proposed transfer, the country to which the individual is being transferred, who the individual concerned is, and any concerns regarding torture or persecution that they might face. Moreover, the respondents declare, and the respondents are the Bush administration, by the way. The people responding are the Bush administration, right? They declare that, quote, the United States seeks humane treatment assurances whenever continued detention is foreseen, including the assurance of access to monitor treatment after the transfer, end quote. Additionally, the respondents maintain that the DoD will not transfer an individual if any concerns about mistreatment of that individual in his home country or prospective destination cannot be resolved. With respect to petitioner speculation that they may be transferred to countries other than their home country of Bahrain, the DoD represents that, quote, of the over 200 transfers, both for release and for continued detention that have occurred over the years so far, they have all been repatriations back to the home country. Thus, the likelihood of the petitioners will be sent to a country other than their home country of Bahrain seems very improbable. And the petitioners' counsel represented during the hearing on the motion that if they requested notices indicate their clients would be transferred to Bahrain, quote, it is certainly more likely than there would be no further litigation. To obtain injunctive release, the petitioners must show that the threatened injury is not merely remote and speculative, quoting from Milk Industry Foundation versus Glickman, a 96 case. Here, the petitioners have failed to show that their threatened injuries are not remote and speculative. Namely, they extensively rely on news reports and articles that suggest the government is involved in a conspiracy to ship Guantanamo Bay detainees to countries where they'll be tortured and detained indefinitely at the behest of the United States. Moreover, there is no evidence in the record that supports the petitioner's allegations that they will be transferred to any country other than Bahrain, or that they will be detained by the authorities in Bahrain if and when they are released by the U.S. Additionally, the petitioners have not submitted any evidence that could lead this court to conclude that the representations made by the Department of Defense with respect to the transfer process are not true. To the contrary, the Department of Defense has submitted declarations of high-level officials outlining the entire process by which transfers are made, along with assurances that detainees will not be subject to torture, mistreatment, or indefinite detention at the behest of the United States. It is clear that the underlying basis for the claims advanced by the petitioners is their basic distrust of the executive branch, which would be, at this point in time, George W. Bush. And the predicate for their distrust is based on nothing more than speculation, innuendo, and secondhand media reports. This is not the stuff that should cause a court to disregard declarations of senior executive branch officials submitted to the court under penalty of perjury. Thus, because respondents directly refute the petitioner's allegations of their potential torture, mistreatment, and indefinite detention to which the United States will in some way be complicit, this court cannot conclude on this record that the petitioners would suffer irreparable harm if they are transferred from the Guantanamo Bay facility. So, to break that down a bit, what injunctive relief is injunctive relief enjoins or stops an individual or an agency from doing something. So it's not a monetary damage, it's kind of relief. It's not a compensatory damage, it's not a punitive damage, it's not monetary in nature. An injunctive relief is getting the court to order somebody to either stop doing something they are doing or to do something they should have been doing that they were not doing. In this case, these 6 Bahraini nationals in Guantanamo Bay are worried that they will be released from Guantanamo and they won't be sent home to Bahrain. They'll be sent home. They'll be sent to Yemen or Afghanistan or Saudi Arabia, where they hear news reports from the New York Times that people are tortured, raped, turned into women, etc. And so this petition is saying, hey, make the U.S. government not send us to one of those countries that's going to do these things to us. Court, give us an order saying we can't be sent to one of these countries. And the court's saying here, we would agree with you that if you were to be sent to one of those countries and those things were to happen, that would be bad. However, that's never happened. None of the 200 detainees who've been sent out of Bahrain, out of Guantanamo from Bahrain have been returned to anywhere but Bahrain. Not only that, but the government says, no, we're going to return these guys to Bahrain, which is where they're from. And so the court says, well, we can't give you an injunction to stop the government from sending you somewhere or places that the government is not actually sending you and has no indication to think they would be sending you. So that's what that case is about. So the next case is Marshall versus Goodyear Tire and Rubber Company. It's a Fifth Circuit case from 1977. The judges are Guyan, Rooney, and Hill, Circuit Court judges. Gwyn, Gowan, G-E-W-I-N, Gowan is the author of the opinion. Okay. After unsuccessful informal attempts to resolve the dispute, the Secretary of Labor sued Goodyear, alleging violation of the Age Discrimination in Employment Act of 1967. The allegation concerned the discharge of William G. Reed Jr. The appellate sought to enjoin further violations and recover Reed's lost wages. The district court found the violations alleged and granted the requested relief, including a nationwide injunction on further violations. So, again, the nationwide injunction is saying, hey, Goodyear, what you did was illegal. We're going to fine you money in this case, but guess what? The court is ordering you to stop violating the Child Labor Relations Act thing all over. Knock it off right now. You're court ordered to do that. If you violate the court order, you're going to be in really much more trouble than you were for this one violation. Appellant, which is Goodyear, primarily complains of the scope of the injunction. The court found a single violation, Reed's discharge, involving only the actions of the Ardendale store manager. This limited finding does not warrant such a broad injunctive relief. Issuance of an injunction rests primarily on the informed discretion of the district court. Yet, injunctive relief is a drastic remedy, not to be applied as a matter of course. In determining the limitations on a district court's discretion to issue an injunction, it is appropriate to look at the ADEA, the Age Discrimination Employment Act of 1967, and also the Fair Labor Standards Act, since the ADA has been enforced through the Fair Standard Labor Act, FLSA provisions, and cases involving other federal statutes regulating employment discrimination. All right. The ADEA Section 7 states, quote, in any action brought to enforce this chapter, the court shall have jurisdiction to grant such legal or equitable relief as may be appropriate to effectuate the purposes of this chapter. The Equal Pay Act, the FLSA, and the ADEA cases all establish that a nationwide or company-wide injunction is appropriate only when the facts indicate a company policy practice is in violation of the statute. For example, the leading ADEA case of Hodgson versus First Federal Savings, we held that the evidence entitled the secretary to a broader injunction than that issued by the district court. The employer had a main office and 5 branches, all in one county. Evidence indicated that the hiring was done centrally by one personnel officer and that he had rejected several applicants for tellers positions because of their age. The district court enjoined future violations of the ADEA with regard to the hiring of tellers. On appeal, this court concluded that the secretary's evidence indicated the existence of a discriminatory hiring policy by the employer. One of the applicants, for example, was rejected for any job, not just a teller job. Moreover, the employer had also placed a newspaper advertisement seeking a young man for the position of a financial advertising assistant. Inasmuch as the proof showed a company policy of hiring discrimination that extended beyond the category of teller positions, a broad injunction against the employer's future discrimination hiring based on age was appropriate. This approach was also seen in Brennan versus J.M. Fields, a 1973 case from the Fifth Circuit. There, this court affirmed the district court's issuance of an injunction against an employer's entire operation, which included more than 60 retail outlets, on the basis of violations of the Equal Pay Act at 3 of them. The secretary defended the injunction on the ground that the New York office's close centralized supervision of wage scales and pay policies indicated the company policy with regard to the pay differential. This court agreed with that conclusion. Conversely, the Second Circuit has held that absent a showing of a policy of discrimination which extends beyond plants at the issue, there is no basis for a nationwide injunction. So if you have a couple plants that are fucking up, there's no reason to issue a whole injunction for the whole nation. Just put an injunction on the plants that are fucking up. The secretary contends that in the instant case, there is sufficient proof of multi-type violations or multiple violations to warrant a nationwide injunction, relying on the proof of a discriminatory job order placed by the Lakeland store. There are several difficulties in accepting this position. The principal difficulty is that the evidence as to the Lakeland incident is slight. The district court made no findings with respect to it, and the court did not rely on it in determining the scope of the injunction. The court made no finding of discriminatory company policy or practice. Indeed, the district judge expressed the view that, quote, Goodyear itself is committed to the principles of the Age Discrimination Act, end quote, and that Reed's discharge was an isolated action of the Ardendale manager, Coleman, who, quote, believes that he can best run an organization if he just has got young people around, close quote. In sum, the district judge relied on the isolated fact that Reed's discriminatory discharge in enjoining the appellant nationwide. Relief should be limited to the Ardendale store. Consequently, we remand the case to the district courts for further considerations within the scope of this proposed injunctive relief. Okay. All right. One more case. But we get what's going on here, right? The problem with that one too, right, was that they said all Goodyear stores, because this one store in Michigan or whatever, in Avondale, Michigan, had one shitty manager who fired a guy because he was too old and he wanted to work with young people. That was wrong, and he should have been in trouble for that, which he was, but that's not enough to say all Goodyear stores nationwide, you have to do this thing. The scope of the violation was isolated, and the injunction should be isolated to that store as well, not to all the stores. And the other ones they talked about in that case, it was a nationwide or a district-wide thing, and the scope of the injunction can only apply to the scope of the level of the business that was doing the wrong stuff, right? All right. So United States versus W.T. Grant Company, a Supreme Court case from 1953. Justice Clark delivered the opinion of the court. All right. For the first time since the enactment of the Clayton Act, which is an antitrust act of 1914, the court is called upon to consider Section 8's prohibitions against interlocking corporate directorates. The government appeals from judgments dismissing civil actions brought against Hancock and the three pairs of corporations which he served as a director of: W.T. Grant Company, the S.H. Crescent Company, the Sears Roebuck Company, and Bondstones and Kroger Company, and the Jewel Tea Company, alleging that the size and competitive relationship of each set of companies brought the interlocks within the reach of Section 8, that the complaints asked the court to order particular interlocks terminated and to enjoin future violations of Section 8 by the individual and the corporate defendants. Soon after the complaints were filed, Hancock resigned from the boards of Kroger, Kress, and Bond, disclosing the resignations by affidavit. All the defendants then moved to dismiss the actions as moot. Moot means what you're asking for you can't get because it's already been given. You're going to ask him to be fired? Well, he's already resigned. So, treated as motions for summary judgment, they were granted by the district judge. He concluded that there was not the slightest threat the defendants will attempt any future activity in violation of Section 8, if they have violated already, which we didn't even reach a finding on. Both sides agree to the abstract proposition that voluntary cessation of allegedly illegal conduct does not deprive the tribunal power to hear and determine the case, i.e., does not make the case moot. A controversy may remain to be settled in such circumstances. A dispute over the legality of the challenged practices could be included. The defendant is free to return to his old ways, if the defendant is free to return to his old ways. Thus, together with a public interest in having the legality of the practices settled, militates against a mootness conclusion. For to say that the case has become moot means that the defendant is entitled to a dismissal of the matter of right, as a matter of right. The courts have held rightly to refuse to grant defendants such a powerful weapon against public law enforcement. The case may nevertheless be moot if the defendant can demonstrate, quote, that there is no reasonable expectation that the wrong will ever be repeated, end quote. It's from the United States versus Aluminum Company of America, a Second Circuit case from 1945. The burden is a heavy one. Here the defendants told the court that the interlocks no longer existed and disclaimed any intention to revive them. Such a profession does not suffice to make a case moot, although it is one of the factors to be considered in determining the appropriateness of granting an injunction against the now discontinued act. Along with its power to hear the case, the court's power to grant injunctive relief survives discontinuance of the illegal conduct. The purpose of an injunction is to prevent future violations, and of course, it can be utilized without a showing of past wrongs. But the moving party must satisfy the court that the relief is needed. The necessary determination is that there exists some cognizable danger of a recurrent violation, something more than the mere possibility which serves to keep the case alive. The Chancellor's decision is based on all circumstances. His discretion is necessarily broad, and a strong showing of abuse must be made to reverse it. To be considered are the bona fides of the expressed intent to comply, the effectiveness of the discontinuance, and in some cases the character of the past violations. The facts relied on by the government to show an abuse of discretion in this case are these. Hancock's 3 interlocking directories viewed as 3 distinct violations, his failure to terminate them until after the suit was filed despite 5 years of administrative attempts to persuade him of their illegality, his expressed refusal to concede that the interlocks in question were illegal under the statute, and his failing to promise not to commit similar violations in the future. Were we sitting as a trial court, this showing might be persuasive, but the government must demonstrate that there is no reasonable basis for the district judge's decision. In this, we think it fails. An individual's proclivity to violate the statute need not be inferred from the fact that 3 violations were charged, particularly since it is only recently that the government has attempted the systematic enforcement of Section 8. The district court was not dealing with a defendant who follows one adjudicated violation with others. The only material before the district judge was the supposed 5 years of administrative persuasion could have supported an inference that during the time the defendant and the Department of Justice were each trying to determine the legality of the directorships. The government's remedy under the statute was plain. Postponement of the suit indicates doubt of the prosecutor's part as much as the intransigence on the defendant's part. How much contrition should be expressed of a defendant is hard to say for us. This surely is a question better addressed to the discretion of the trial court. The same can be said for the limited disclaimer of future intent. We conclude that although actions were not moot, no abuse of discretion was demonstrated in the trial court's refusal to award injunctive relief. Moreover, the court stated its dismissals, quote, would not be a bar to a new suit in such a case where possible violations were to arise in the future. The judgment is affirmed. 2 dissenting opinions now from Justice Douglas and Justice Black. Well, Justice Douglas, with whom Justice Black concurs. It's a very short one, so we can do this. We'll get through it. Mr. Hancock served as a director for each of 3 sets of companies, which, on the state of the pleadings before us, we must assume to have been competitive. The fact he resigned under the pressure of these proceedings should not dispose the case. We are dealing here with professionals whose technique for controlling enterprises and building empires was fully developed and was well known long before Justice Brandeis was crying out against the evils of the money trust. Mr. Hancock is and has been for some years a partner in the investment banking firm of the Lehman Brothers. In 1940, he testified that when Lehman Brothers did financing for a company, it was their traditional practice to ask for representation on their board of directors. The fact that the Lehman partner resigned to avoid a decision on the merits has little, if any, relevancy to the issue in the case, for we are here concerned with what the proclivity of the Lehman Brothers trading house to indulge in this practice. The relevant issues here have never been weighed in the case. The district court's ruling would be entitled to a presumption of validity if those various factors had been considered. But the district court made no such considered judgment. It disposed of the case on the basis of mootness, a ruling now conceded to be erroneous. The case should go back for a consideration of the nature and the extent of the web which the investment banking house has woven over industry and its effect on the, quote, elimination of competition within the meaning of Section 8 of the Clayton Act. Unless we know that much, we are in no position to judge the service an injunction against future violations may or may not do. That's the case, and that's the reading. Yep. All right, people. Y'all have a good one. Tip your waitresses, tip your bartenders, tip your hostesses. Have a good one. Get some rest, and we'll see you all tomorrow. God bless. Take care, everybody. Good night.